the topic of Rule 126, search and seizure, is very important, and it must be understand even by a simple mind to use as defenses when your place is being searched, when a thing is to be seized from you, to be taken from you. So it's very important to know all about this. So let us go to exemption to search warrant requirement. What are those instances in which there is no need for search warrant? First is the search incidental to a lawful arrest. Again, search incidental to a lawful arrest. That is in section 13 of Rule 126. That's the first. That is an exemption to the general rule. We will talk about this. Next, seizure of evidence in plain view, the plain view doctrine. Next, it's the stop and frisk. Stop and frisk. Next is the exigent or emergency circumstances. Next is the consented warrantless search. Consented warrantless search. Example of this consented is the search of vessels and aircraft, custom search, inspection of buildings and other premises to the enforcement of fire, sanitary, or building regulations. The BFP, inspecting buildings for fire, sanitary, the Department of Health, building, the city engineers, to see if they are following the laws, the rules, the regulations. Now, let's go to the very first exemption is the search incidental to a lawful arrest. Section 13, Rule 126. A person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. So it should be a person lawfully arrested. So when can there be a warrantless arrest? The very first is that a flagrante delicto. A person is in the presence of a peace officer or private individual. The accused is actually committing, attempting to commit, or is about to commit a crime. So, flagrante delicto can be that person, that accused may be arrested. Next, the hot pursuit in which, based from a personal knowledge that the accused has committed a crime or already committed a crime, may officers pursue or make an hot pursuit for the arrest of the accused. Last is the escapee. If the person or is an escapee of a penal institution who is serving sentence or is convicted or placed in a detention for commission of a crime and escape, then therefore there can be a warrantless arrest. So if that person is arrested without the benefit of a warrant, there is already a lawful arrest, then immediately the officer arresting the person may search for dangerous weapons like knife, guns, or anything which may have been used or constitute a proof in the commission of an offense without a search warrant. So simply checking his pockets, checking his jacket, checking his bags if he is carrying with him bags. Those are only within the reach of the accused. Those only within the reach of the officer that will only stop or that will search for anything that will prove that there is a commission of crime. That's search incident to a lawful arrest. It should be a lawful arrest first, then search. Again, there must be a prior lawful arrest before a search is being done. That is why search incident. The search here is only an incident to a lawful arrest. It is not the main purpose of the officer. The main purpose of the officer must be arrest, provided it is lawful. Then it is only an incidental to the lawful arrest is the searching. So after a lawful arrest, make a search. For what? For dangerous weapons or anything may have been used or constitute proof the commission of an offense without a search warrant. Next, example. In addition to a search incident to lawful arrest, wherein the search is limited to search for dangerous weapon or for anything that may have been used for commission of the crime or offense to prove a commission of the offense. However, search can be extended within the area of immediate control of the arrest. So, again, the search is only in the immediate control of arrest. So, it means to say, only within the reach of the accused, only within the reach of the arresting officer or the one who is arresting. So only within the reach. So if the person about to arrest is driving a motorcycle, then the driver lose himself from the motor 5 meters away, very far, because of a crash, crashing a wall. The rider blew 5 meters away, or let's make a 3 meters away. Then the arresting officer may not able to search for the motor. What's in the motor? Only within the reach. Only within the reach of the arrest. That is in Valeroso versus CA. Thus, Eggs is arrested. Besides his car, can search be extended to X's car? The answer is yes. So, if accused is arrested beside his car, so the car is within the reach. So therefore, the search can be extended inside the car. Again, if X is arrested besides his car, can search be extended to X's car? The answer is yes, because the arrest is made because the car is within the reach of the arrest. Next, why is arrested while on board of his motorcycle? So, motorcycle. Why is arrested while on board of his motorcycle? Can search be extended to his motorcycle? The answer is yes. Again, why is arrested while on board? It means to say he is sitting on his motorcycle. Why is sitting on his motorcycle while he is being arrested? So within the reach. What if he was he ran away from his motor? Leaving his motor behind. Why leaves his motor, leaving his motor behind, and about 5 meters away, he was arrested by the officer. Can you search for the motor? The answer is no. You cannot anymore search the motor because it is already far from the reach of the arrest. It's already 5 meters away from the arrest. So therefore, again, a search can only be made to a motorcycle if the person to be arrested is on board of his motorcycle. What if he ran away, leaving his motor behind 5 meters away? The motor cannot anymore be searched because it is already far from the reach of the arrest. That's the logic behind. Next, there's however. If X is arrested outside his house, wherein his house is just 15 meters away, the search cannot be extended to X house because the house is not anymore within the area of immediate control of the arrest. So again, if X is arrested outside his house, wherein his house is just 15 meters away, the search cannot be extended to X house because the house is not anymore within the area of immediate control of the arrest. So it's just like the motorcycle. If the person to be arrested leaves his motor behind, runs 5 meters away from his motor, and then he was arrested, the motorcycle cannot anymore be searched because it is already far from the control of the arrest. It is not anymore an immediate control of the arrest. The law requires an immediate control, so within the reach only of the arrest. Search of moving vehicles. In the checkpoints, peace officers are limited only to routine checks where examination of the vehicle is limited to visual inspection. Again, peace officers are limited only to routine checks where examination of the vehicle is limited to visual inspection. So only visual inspection. Officers during checkpoint, they will make only a visual inspections. What do you mean by visual? No? Just only look only. Before the vehicle may be subjected to extensive search, such would be permissible only if the officers made it upon a probable cause. That is in People versus Libano. As a general rule, limited visual inspection. But if the officer made it upon a probable cause, if there is probable cause, that's the time there can be an extensive search. So that is why they are already requiring vehicle to open the seat, the back, or inside, what's inside of the car, what's inside of the U-box of the motorcycle. They are searching already for the motorcycle, but only for visual. They cannot touch anything inside your U-box. They cannot touch anything inside the car, inside the vehicle. They will just only make a visual inspection. That is already an extensive search. They will just only make a visual inspection to what is inside of the U-box of the motorcycle, to what is inside of the car. It should be made upon a probable cause. If there is no probable cause, they will just only look at you. They will just only merely stop you, make a limited visual, very limited, just only for a centimeters away, looking at your motor, at the plate number of the car. looking at the cargo, looking at the description, the car, just only a limited visual inspection. Checkpoints. Only visual search. Routinary search is valid. That is for checkpoint. Okay? That is only visual search or routinary search. Limited visual inspection unless there is probable cause. Now, plain view doctrine. Search of evidence in plain view. Again, this is going to review in Liwanag versus People, wherein the law enforcement officers in search of the evidence have a prior justification. They have a prior justification conducting search with warrant for an intrusion or in a position from which they can view a particular area. So, they can only see things very clear upon entering. If they will search in a house, they can immediately see the object. The discovery of the evidence in a plain view is inadvertent. It means to say there is no interference, there is no covering of the object. The object is not covered by a cloth, covered by a newspaper. It's very clear, immediately can see it. There is no, it is inadvertent. There is no cover. There is no hindrance in looking for it. It's only a plain view, very plain. There is no distraction. It's very plain, very clear. And the last is it is immediately apparent to the officers that the item they observe may be evidence of a crime, a contraband, or otherwise subject to seizure, provided that the object that they have seen in their plain view is connected or apparently or immediately can be an evidence or can be a proof of a crime. That is why they can seize it. Next, stop and frisk. So if you will be entering the grocery, an establishment, you will stop, frisk, and you will be checked by their object to check if there is metal in your body. That is stop and frisk. A genuine reason must exist. A genuine reason must exist in light of the police officer's experience and surrounding condition to warrant the belief that the person detained has weapons concealed about him. Twofold interest here in stop and frisk. Effective crime prevention and detection. So that's the importance of stop and frisk. It's to prevent a crime. It's a detection of crime. To detect, to prevent crime. Safety and self-preservation, which permit the police officer to take steps to assure himself that the person with whom he deals is not armed. That is in People versus Comprado. Safety and self-preservation, which permit the police officer to take steps to assure himself that the person with whom he deals is not armed. So, the police officer needs to protect himself by making a stop and frisk to see if he deals with a person without possessing any dangerous weapon. Thus, in Posada versus CA, two policemen were conducting a surveillance within the premises of the Rizal Memorial Colleges. Two police officers conducting surveillance within the premises of the Rizal Memorial Colleges when they spotted the accused carrying a buri bag and acting suspiciously. They approached the accused and identified themselves as police officers. The accused attempted to flee, but his attempt to get away was thwarted by the policemen, who then checked the booty bag wherein they found guns, ammunition, and grenade. This search is valid. This is in Posada versus CA. Police officers are conducting surveillance. Then they have seen the accused suspiciously carrying a booty bag with him, and when these police officers approached this accused, he immediately flee from the officers, but he was thwarted carrying with him his booty bag. Then therefore, while he was arrested because of suspicious action, the act of fleeing while police officers are approaching is a fact or a circumstance of a probable cause that there is suspicious act committed or is about to commit by the accused. So it can be a ground for arrest without the valid of a warrant, since the booty bag is within the reach of the accused. Then search can be made also to the booty bag. Those items found in the booty bag may be used against as evidence to the accused. In People versus Koga ed 2014, it describes here the stop and frisk and the search incident to lawful arrest. It differentiates that stop and frisk and search incident to lawful arrest. In stop and frisk, there is no crime yet has been committed. No crime has been committed. Like the accused, carrying him, accused in the Posada versus CA. The accused did not make any crime yet. But the act of fleeing from the police officers, attempting to flee, is a circumstance. Search is preventive in nature and for the safety and self-preservation of the police officer. So that's the right of the police officer. The right, it's their exercise. The police officers must exercise the stop and frisk for self-preservation and for crime prevention and detection. That is the purpose of stop and frisk, in which the accused did not commit a crime yet, but because of suspicious act, the act of fleeing can be a ground to stop the accused. While search incident to lawful arrest, there is a crime committed in flagrante delicto. There is a crime already. Search incident to lawful arrest, there is a crime. That's the difference between stop and frisk and search incident to lawful arrest. In stop and frisk, there is no crime has been committed. But in search incident to lawful arrest, there is already flagrante delicto. Search is done to preserve evidence and to ensure there is no weapons. The last one is consented search. A person to be searched is given his consent. A person to be searched is given his consent to the law enforcer in areas in which such person has reasonable expectation of privacy. Again, under consented search, a person to be searched is given his consent to the lawful officer. So, giving consent to the lawful officer to be searched in areas in which such person has reasonable expectation of privacy. It cannot be inferred by silence. Also, it cannot be presumed. That is versus People versus Kogain. Consented search cannot be presumed, cannot be inferred by silence. It means to say, person to be searched is only silence, giving no act, giving no consent, giving no words of consenting the officers. It's the consented search is not presumed. It is not presumed. It is not inferred. You cannot tell that there is consented search if there is silence. No, there can be no consented search if there is silence. It is the prosecution that shall prove with clear and convincing evidence that there is waiver of right. It's the prosecution already. See to it that there is clear and convincing evidence that there is waiver of right. Next, requisite of consented search. The right exists. The right exists. The person has the right not to be searched. The person involved had knowledge, either actual or constructive, of the existence of such right. The said person had no actual intention to relinquish the right. So those are the requisites for a consented search. Consented search in which the person to be searched is giving his consent to the law enforcer, to the enforcers, that he is be subject to search. It should be the person to be searched must give the consent, giving his words of consent, because it is the right of a person to be that's a constitutional right, that a person must be protected from unreasonable searches and seizures without a probable cause, without the benefit of a search warrant. That's for searches and seizures of Rule 126.